there are issues, though, where it is established that those rights are not absolute, meaning that there are also clauses to the effect that there are moments where those restrictions could impair those freedom. But what happened today in Kogi State, the actions of the state government, the action of OKE local government, and the action of the police saying that cancel the homecoming. Let's get some legal perspectives on the one. A sound one and a very informed one at that. Mr. Jiti Ogunye is live for us in our Lagos studio to give us some insight on that. Thank you so much, Mr. Ogunye, for joining us tonight.
It's my pleasure for inviting me. Thanks, you. Good evening, Nigeria.
Yeah. Thank you, sir. First and foremost, I would like you to play the role of a lecturer and one adult tonight that has a lot of knowledge to share as far as the Nigerian law is concerned. But I'd like you to help me hit the nail on the head. Give us a summary or a very quick understanding of freedom of association, freedom of movement, and the limitations.
Well, Nigeria is a constitutional democracy. So we have the 1999 Constitution as amended many times. And in that Constitution, we have specially entrenched rights, which are called fundamental rights of Nigerian citizens. These are rights that are regarded as inalienable. They're fundamental, and Nigerians are given the liberty under the law to exercise these rights. Now, there are other rights in other laws, but if any power or rights stipulated or written into any other law, conflict with the provisions of the Constitution, particularly the especially entrenched fundamental human rights, of course, by virtue of the supremacy clause in the Constitution, I reference section 1, subsection 2 and 3, that law would, to the extent of its inconsistency, be void. Now, there are three rights that are usually exercised together, under the provision, under the fundamental rights provision in the Constitution. And these three rights are the three rights that I dare say are implicated, if not violated, or attempted to be violated by what is played out in Kogi State. The first is Section 39, the right to freedom of expression and the press. Nigerians have the right to express themselves. The expression may take many forms, including wearing, clothes, doing some things, not just verbal utterances. It includes written works, etc., etc. And now we have the social media. The second is the right to peaceful assembly and association, Section 40, which in your intro you made mention of. And the third is the right to freedom of movement, which is Section 41, giving Nigerians the right to move within Nigeria and to reside in any part of Nigeria. It also includes the right of ingress into Nigeria and egress into Nigeria. So these are the three rights that are very important for the purpose of our discussion. And so when there is a law, and there used to be a law, and I think I will make mention of that in a short while, the Public Order Act had provisions constraining these rights or violating these rights. The court will not hesitate to strike down that law and say that it's inconsistent with the provisions of the Nigerian Constitution, particularly the referenced fundamental right. And that's what the Court of Appeal did exactly in a 2007 decision, that notorious decision, AMPP and IGP. In that case, some political parties, 12 in number, including some of them that are defunct now, came together and they filed an action to challenge the ability restraint that they shouldn't hold rallies and all that. And the Court of Appeal looked at the Public Orders Act It's a slim law with all its provisions, and then struck down many of the provisions, about 6 of them in all, and declared them to be inconsistent with the provisions in the Constitution that allow Nigerians the right to associate and assemble and express themselves and move about as they may like, and that police or law enforcement authorities only have the duty to protect the citizens and all that. And I think that that's what that sentiment or that position was what was now belatedly written into the new Police Act, which is not so new anymore now because it's been passed for some years now, in Section 83, subsection 4, which mandates the police, once they get information that some Nigerians are going to have procession, they are going to conduct marches, or they are going to conduct rallies, that the police have a duty to go there and protect them. I think that it was that position of, in that case, that the legislature deemed it fit to enact into that section. Now, finally, generally, there is a provision in the Constitution, and that's Section 45, that provides for derogation. It says generally that nothing will be unconstitutional about any law that, is reasonable in a democratic society, that may appear or tend to, constrain those rights once they are justifiable in a democratic society. And this is what has been cited many times when we're talking about security, national interest, national security, and personal security and all that, which people say now and again. My view, in sum, is that in a democracy, massing up, gathering, speaking, including public speaking, conducting rallies, are essential elements of a democratic society, of a free society. And so, government, without reason, government at any level, shouldn't be too eager to constrain this, except there are good reasons and justifiable reasons and lawful reason, solid legal ground to constrain this right. I listened to your interviewee speak about the suspended senator violating an instruction. And I listened carefully. Instruction is no provision of the law. The suspended senator was saying that he had not violated any law. And you put him to task, has he violated any law? He said she violated an instruction. There was a ban, there shouldn't be movement, that's an instruction. A governor of a state can't just issue a gubernatorial instruction, and expect compliance, and that if people don't comply, then they've committed an offense. So it doesn't work like that, under the law. There could be some exercise of emergency powers, even without formal declaration of a state of emergency in a particular state. For example, if there's a breakdown of law and order, actual breakdown of law and order, there is a crisis, burning, arson and looting and all that, and to ensure that people stay indoors and are locked down so that there will be no continuation. Curfew may be imposed, movement may be restricted, and so on and so forth. But, in normal times, you can't just say, I'm relying on security reports, and so I'm giving a ban gubernatorially, and that once that instruction, quote and unquote, is violated, then it amounts to violating the law.
Yeah. Mr. Ogunye, let me jump in quickly. And thank you for the background. And I think it suffices to give us an understanding of where we are coming from as a people, as far as the jurisprudence on the freedom, the section 39, 40, and 41 of our Constitution is concerned, because it affects the matter of which we are considering tonight. But I will also like everyone. You mentioned a very notorious case. I'd like everyone to look at it. I love to look at cases from the trial court to the appellate court to the very point at the Supreme Court, because it's always very important to understand the debate that brought the Supreme Court to that very sound decision in law. At the appellate court, which was a case delivered in December of 2007, the appellate, the part of the debate was whether or not you need a police permit and a police authority to be able to hold a rally or a gathering. And the Supreme Court has rested that matter to say wherever a rally is going on, you have to go and ensure order and peace. Now, Mr. Ogunye, let me take you one after the other. First and foremost, I'll take you to what the government of Kogi State said. First and foremost, the government of Kogi State said that the rally, based on information they have, and I'm going to quote what the government of Kogi State says. It says, quote, in view of this and effective immediately, the Kogi State government has placed a total ban on all forms of rallies, on public gatherings that have the potential to disrupt public peace. They went further to say this decision has been necessitated by intelligence reports indicating that certain individuals are plotting to infiltrate the state under the guise of organizing rallies, using fake security personnel to foment trouble and compromise the security of law-abiding citizens of RDS. While the government recognizes the constitutional rights of citizens to gather and express themselves, security considerations must take precedence in the interest of public safety. As such, no individual, group, or organization is permitted to hold any form of rally within the state until further notice. The instructions were clear. Mr. Ogunye, based on the Supreme Court judgment and the extant laws and the Constitution of the Federal Republic, is the government of Kogi State right to have given that directive?
You know, in our climb, government and government functionaries issue directives, give orders, and, make prescription. Our duty, and my call this evening here, is to say that in certain respects, what government officials take the liberty to do may not be legal, may not be lawful. I've just taken us through what has been decided in the past in this country. Let me state clearly here that I understand the issue of security in all situations, public order and public safety. As a matter of fact, it can be argued, and I'm not playing the devil's advocate, that given the facts of the matter, but I could see that, there is an attempt to play the ostrich here, that this suspended senator is not the one particularly being targeted, that this ban is for the public good and all that. But if we were to come into the open and come clearly and say this, there's a way in which it could be argued that, hey, this senator had an issue with the federal parliament, the Senate specifically, been suspended. She's been moving all over the world to give vent to her anger. She's been saying a lot of things, some of them not easily verifiable and all that. And so she says she wants to come to town. And so we have a duty as a state, because of the political differences, because of the fact that we have different political affiliations, and because of the antecedent, particularly during the elections, when there was crisis in that area, the allegation that road was destroyed, particularly because of this same senator, and that it took our time to get to the Senate eventually, because of those antecedents. And that's why I'm saying there is no need playing the ostrich. We have a duty as a state to ensure that there is security, including our own security, because we don't want any situation where a fifth columnist or an opportunist will want to intervene and cause violence and then target the senator and then blame it on the state government. So we will want to work with our team to then provide security on that occasion. Now, the state government is aware that some of the constituents of these senators are moving all over the place saying they want to recall her. So if people want to recall her from the Senate, doesn't she have the right to go to her constituent and explain to them why she should not be recalled? I mean, that is only fair. So what I'm saying, in effect, is that political tolerance and accommodation is the key when we're talking about democracy. You know, because it is about argument, it's about persuasion. It's not by dictation and it's not by instruction. Democracy is by persuasion. It's not by compulsion. So, and everybody will have the right to express his own view and then say whatever he wants to say. So I'm saying that, yes, I can understand the perspective of security, the perspective of intelligence and all that, and usually it's off limit, including the security votes in Nigeria. There is no government in Nigeria that been able to give account of security votes. They say, no, we can't say it. The other time, I think that it was governor of Ondo State that was being asked before the election, how much is this security vote you are talking about? No, he says it's a security matter. You can't even disclose the security vote. So, in the same vein, it may be argued that you cannot even disclose what the sources of the intelligence, is, and the reports. I understand that, but I'm saying that when you then weigh the situation carefully, and you want to be fair, there is no need to engage in what I call a gratuitous lionization of that personality.
Mr. Ogunye, I want us to anchor in this, and I'm being told I have just about 30 seconds to do so. The local government of Okeyi has said there is a curfew. And the police is also saying cancel the event. As a lawyer, Mr. Ogunye, with all of these layers of caution and cancellation and curfew and all of that, do you think Senator Natasha Akpoti might be legally in trouble?
I'll be brief. In any case, the event had held. It didn't hold by road, it held by air. So, if the state government is saying that she's violated a law, it will be interesting to see the law that she's violated and whether she can be brought to justice. But I listen again to your interview carefully. You said the person violated an instruction. So, as a lawyer, I'll be interested in seeing a law being violated and in seeing justice being done to the violator and then to the state and to everybody in that state.
Thank you so much, Mr. Ogunye. Always a pleasure listening to you analyze these legal issues for us. But thank you so much indeed for your time. I appreciate it.